Joining us now to discuss all of this, our legal panel. Doug Burns, a former federal prosecutor and criminal defense attorney. Brian Claypool is a criminal defense attorney as well. So this kid, who has been in jail for 9 years now,
yes,
is not going to get out because the prosecutor, thinks the judge is wrong? Do you want to explain it?
Yeah, it was actually more procedural than substantive, so let me just explain real quickly. What happened was, when the habeas corpus petition was granted, based, by the way, on the fact that his confession was somewhat coerced, but put that to the side, the judge said that if the prosecutors don't move forward with a retrial, he is to be released in 90 days, which is 90 days from August 14th. Takes us right into the middle of November. The state appealed, and the appellate court basically just said, wait a minute, let's just stay it, meaning in simple English, we're going to not make any decision on his release until we can actually look at the entire picture. So it's really procedural. It's not so much that they're saying he must be jailed. We're just going to hold it in abeyance until we can look at the full picture.
Anybody who watched this documentary, Brian, it was, to be fair, it was one-sided. It was from the point of view of Stephen Avery and Brendan Dassey. But anybody who watched the video of the so-called confession of Brendan Dassey, when he tells the investigators, you know, I guess what they wanted to hear, and then said, hey, I got to go to school now after just confessing to a murder. The guy is not 100% mentally there, and the judge even said that in his finding.
John, shame on the Wisconsin State Attorney General for blocking the release of Brendan Dassey. And I'll tell you why. Because there were the judge, Duffin, issued a 91-page order. He sat and carefully reviewed this, and he said that Dassey should go free. Now, there were restrictions, John, that were imposed upon him, too.
Right.
He can only live in a certain part of Wisconsin. He can't own a firearm. He can't go near Stephen Avery. He can't apply for a passport. So you tell me why that's not good enough to allow him to go free. And then getting back to your question, people should know that Dassey had the mentality of a 9-year-old. I have a little girl who's 10.
Right.
I couldn't imagine her sitting in there being interrogated without an adult or lawyer there.
Let me read from part of that 91-page report that Brian just mentioned.
Yes.
The judge found the investigators repeatedly claimed to already know what happened on October 31st, the day of the murder, and assured Dassey he had nothing to worry about. These repeated false promises, when considered in conjunction with all relevant factors, most especially Dassey's age, intellectual deficits, and the absence of a supportive adult, rendered Dassey's confession involuntary.
Yeah, I read through most of that opinion myself, and it's interesting because the police can make certain misrepresentations. They can say, we know exactly what happened, we know all of the facts.
And they said that to him.
But you can't, they did say that, but the more problematic part, much more problematic, John, is when they said, don't worry, you're going to be fine, you're not going to get in trouble. That's what really bothered the magistrate. And the point is, just to echo what you guys are saying, his limited intelligence, no lawyer there, no parent there, when the mother claimed that she had asked to be there, coupled with this coercion, that's why the judge ruled the way he did.
Yeah, this is almost like pay-to-play justice, you know, the pay-to-play with Hillary Clinton on the Clinton Foundation. This is like pay-to-play justice. Now that I heard, too, that the State Attorney General wants to talk to Brendan Dassey to find out whether he will agree to not testify for Stephen Avery, because Avery's lawyer is trying to get a new trial now. In other words, they're going to say, okay, we'll let you go free for now. We won't retry you as long as you agree to not do anything that will hurt our chances to make sure that Stephen Avery stays in jail, because his lawyer's trying to get him out based on the blood testing. His lawyer is saying that there's new DNA testing that can show that Avery's blood in Hallbeck's Toyota van was older than the van.
Well, it's very ironic because Avery had been cleared for a very serious crime in the mid-'80s by DNA, which throws kind of a wrinkle. Of course, that's irrelevant, obviously, in terms of the later case. But the question that emerges, I don't have any answers, is will the fact that the judge threw out the Dassey confession have any impact on Avery's chances for some relief, John?
Well, it's my understanding that Avery has exhausted his appeals.
No, he has.
But
He has.
But his lawyer just recently filed a new motion to try to get a new trial based on there's new DNA testing of blood to determine how old blood is. The argument is the blood was planted in the Toyota.
And
By
also,
the kids.
real quick, that's why I have habeas corpus. In other words, you exhausted all your appeals. Habeas is separate. You know.
it is a fascinating case. We'll try to keep our viewers updated. Thanks very much, both of you.
My pleasure, John.
Thanks, John.
All right, Jenna.